You may recall in particular one debate in which Hillary Clinton talked about the Heller decision, the most important decision Justice Scalia ever authored. And Hillary Clinton, you may recall, talked about Heller was really all about protecting toddlers. Well, I'll confess I know something about Heller because I represented Texas and 30 other states in Heller defending the Second Amendment right to keep and bear arms. And you know, it's striking. You can read the Heller majority opinion, you can read the dissent, and you can search in vain. Do you know what word is found nowhere in Heller? Toddler. Heller had absolutely nothing to do with toddlers. Instead, Heller concerned an individual, Dick Anthony Heller, a federal police officer who wanted to exercise his constitutional right to keep and bear arms in his home. And under the laws of the District of Columbia, it was a criminal offense. D.C. made it a crime for anyone to possess a handgun. And D.C. also made it a crime for anyone to possess an operable long gun, a rifle or a shotgun. Indeed, the laws in D.C. were so nutty that if you had, say, a shotgun in the closet with a trigger lock on it, and a criminal was breaking into your house, was crawling through the window to injure your children, and you took that shotgun and removed the trigger lock, you would have committed a crime in the District of Columbia. That's what Heller was about. It was about whether or not the Second Amendment means what it says. Hillary Clinton in this last election promised she would appoint justices who would overturn Heller. And it's worth pausing to reflect what that would mean. The position of the dissenters in Heller was not that some reasonable restrictions are sometimes permissible. The position of the dissenters in Heller was far more radical than that. 4 justices on the Supreme Court said the Second Amendment does not protect any individual right to keep and bear arms whatsoever. Their position was it is only a, quote, collective right of the militia, which is fancy lawyer talk for a non-existent right. Had the dissenters prevailed, the result would have been the Second Amendment would effectively have been erased from the Bill of Rights. It would have meant that any state, any locality, or the federal government could pass a law making it a crime for you or me or anybody else to exercise our Second Amendment right to own even a single firearm, and we would not have had any judicial avenue to challenge that.